So the first topic that we're going to talk about is the Corporate Transparency Act. And it's going to frustrate and anger people. It's going to be a real headache for not only clients, business owners that are affected, anyone that's done an estate or asset protection plan, has multiple entities, if not even more, that are all going to have to file reports. It's new. This has never happened before. And it's going to be not only a significant administrative burden, but I think it's going to really bother people. It bothers me in terms of just more government disclosures that government has on record. And it's I don't want to say anything political, but it certainly gets worrisome how confidential government data is not always kept so confidential. And now they're going to have more information from us and you on all of our entities. Alan, do you want to make any general comments about the CTA before we start talking about it?
No, I agree with your concerns. I'm glad that it doesn't apply to trusts. It applies to basically any entity that you would file with a Secretary of State, but it will be a lot of paperwork. And it surprises me that they said the average cost of a filing will only be $85.
Come on.
I know. I can't answer my phone or answer an email for $85. So it's going to be a challenge for a lot of accountants and lawyers, I think.
Listen, Alan spilled the beans. I think I have it in a later slide, but let me just say it now. There is no reporting at present for trusts, but the Biden administration's Green Book does have really extensive provisions that are actually even more invasive, I think that's the right word, than the Corporate Transparency Act is for entities as to trusts. Now, I don't think it's very likely that much, if anything, will be passed from the Biden Green Book. That being said, you can never predict what might happen in Congress with, backroom deals that are made, like with the deficit budget debt ceiling negotiations. Who knows what will get passed? But I think, and this is really important, is the big picture. The America has not had the kind of reporting that many other developed countries have had for years. And I think we're kind of playing catch up, and we are going to start moving in that direction. The Corporate Transparency Act is one of them. And this was a bipartisan piece of legislation. So we may very well find that all these detailed disclosures on trusts may also come into play. So I think the bottom line is we all need to just come to terms with this, that the government is going to get more reporting. And it's not only the cost or the invasive feeling of it, but in some cases, this could really have significant ramifications. I'm concerned for people that are worried about personal safety, that as the disclosures grow and more people may get access to it, what might that mean to compromise people's confidentiality to whatever extent you still have any? So let's talk about the Corporate Transparency Act to give you a better idea, because effective January 1 next year, all new entities formed will have to do it. So it requires privately held entities to report pretty detailed information to the Treasury Department. And supposedly they say that only appropriate government agencies will have access to this information. I'm concerned what that may mean in practice and who may have access to it. I'm also concerned, and Alan, I didn't write about this in the slides, but if you're going through a divorce or a lawsuit, plaintiff's counsel's coming after you. Now that these filings exist, can somebody ask for them as part of the disclosures in a court proceeding?
I would think so.
That's bad.
Returns.
And why is this any different? So again, if you have an LLC that you set up to hold investments, to own a rental property, to own your law practice, or an S corp, or a LLC or S corporation to hold securities that you have for a second layer or asset protection, and that's then fractionalized and owned by, all those are covered. All those are covered. You have an LLC set up to own a vacation home, it's going to probably be covered. So it's pretty broad. And I think that the reporting will feel invasive. It's going to cover a lot of entities, but it goes further. In the second bullet point on slide 6, it not just applies to the entities, but to the beneficial owners of the entities. And wait till you hear how that they define that. Very, very broad. It's not just what you would consider an owner. So it's going to be costly. It's going to take time. As Alan just pointed out, this may now be documents that if you're involved in a lawsuit or divorce or other actions, somebody may ask for because you're required to file it. And I think Alan's analogies make sense. Why is it any different than an income tax return? They ask for those in cases pretty routinely. So why not that? Hang on one second. It tries to create a comprehensive, searchable national database of information on entities. That's worrisome in itself. The objective is to pierce through the entities, the form of the entity, and identify the people behind the entity. So if you have an entity that's owned by trusts, they may pierce through that. Who are the owners? If you feel that you've used an entity to own real estate, you're going to have to disclose your name as the owner of that entity and your personal home address, not a PO box. Many of us are accustomed to using our PO box or our business mailing address for all sorts of things because we don't really feel comfortable. I'm saying we because I'm including myself in this, and probably Alan as well. We don't feel comfortable having our home address on lots of tax and governmental filings, but you're going to have to use your home address, not a PO box. So privacy is disappearing. Why are they doing all this? The government is just like governments in other developed countries, trying to get information in order to prevent the use of entities for tax evasion, money laundering, and other financial crimes. And they're trying to get the US on par with these other entities. So the principals and owners of all the different types of entities, limited liability companies, limited partnerships, S corporations, other closely held entities will all be affected. If you have, for example, and it's very common in real estate, let's say you own 20 or 30 rental properties, common to have a separate LLC for each one of those rental properties to prevent a domino effect. If a tenant has a suit on one property, the other properties are protected in LLCs. Every one of those entities may have to report. For some clients, this is going to be a pretty significant undertaking. We routinely create LLCs and layers of LLCs for asset protection, estate planning, for a variety of reasons. Every one of those will now be subject to a reporting requirement. Alan, if I have a disregarded LLC that I own 100% of, so it's not filing a tax return, do I have to file, but I don't file a tax return? Do I have to file under the CTA?
Absolutely. Absolutely. That's what they're after. They don't want anybody to be able to hide assets. So I think they figure if citizens know that they have to report the entity, they're less likely to hide things in the entity.
So the bottom line is everything's affected. And I know a lot of people, that's why I asked the question to Alan now, if you have a disregarded entity like an LLC that you own 100% of, so it doesn't file a tax return, or a grant or trust owns it, doesn't exempt it. And I gave the example before, but lots of people have vacation homes held in LLCs. It's a great way to have rules and regulations about how family members use the home. It's a great way to have it held by a trust in a different jurisdiction. People set up LLCs to hold artwork or other property for a variety of reasons, all going to be tagged by this legislation. And the exceptions, Alan, do you want to talk about some of the exceptions at all?
The exceptions don't apply to anyone who's watching this webinar.
That sums it up. That's funny.
But I will say, Marty, I'll be able to buy a new house or something from all the revenue, because when we go and we do our annual reports for all the clients that we do annual reports for, here's another piece of paper with another 4 pieces of information, another $100 to $150 per entity per year. And the clients will say, gosh darn it, that darn government, they made us pay Alan or made us pay our CPA another $100, $150 a year. But What I like about it, Marty, is the clients who would say, I don't want to report this. I don't want anyone to know. Actually, I'm hiding money in this LLC. Well, they don't have to be my clients anymore, and that's okay with me. I personally don't mind that the IRS and some federal agency know all about me, because I figure if they want to know all about me, they're going to know all about me anyway. But they probably can't. First of all, this is the U.S. government, so they probably won't even be able to use it themselves for the first 5 years. It probably won't even work.
So, a couple of comments. I don't think it's going to be $150. It may be after the first one's done, so you have all the information. But it's going to take some time. And we're going to talk before we get through this about some of the things you may want to start doing right now. But here's the bottom of slide 10 is where, oh, and by the way, another comment. Alan mentioned lawyers filing versus CPAs. I kind of, it sounds like a simple kind of return that CPAs would file, but CPAs don't often have all the entity documentation. They may have nothing on their radar at all if it's a disregarded entity. They may not understand or have the details of the trusts and various layers of entities involved in the ownership of various entities. I kind of have a feeling that a lot of this may end up on the lawyer's plate more than the accountant's plate. Alan, any thoughts on that?
I will feel more comfortable doing them ourselves for the disregarded LLCs, because the CPAs, like you say, they just there would be too many mistakes made because they don't have the direct information. They'll just
They
ask
don't
the
have it.
they'll ask the client will give them the wrong information, and then it'll be done wrong inadvertently. Whereas we have the information, it's in our file. It takes a secretary 9 minutes to look it up, and that's just a fact of life.
Look at the bottom of page 10. So when I first described this, I used the language that they use, that owners, but they use beneficial owners. What's a beneficial owner? That is the person controlling the entity. The government, through this reporting requirement, is looking to see who really is controlling an entity. And it's not just necessarily the nominal owner, it's who's actually controlling it. And in addition to disclosing your home address, the beneficial owner is going to have to provide a copy of their passport or driver's license. So this is pretty invasive. That's far more than goes on a tax return typically. Now, here's one of the things that really worries me is what happens when information changes. Alan, you want to chat about that a little bit?
Go ahead and tell us.
So if you have a change in information, that has to be reported within 30 days. So let's say the beneficial owner, and we're going to talk more about that in a minute, changes their home address. Within 30 days of that address change, you're going to have to file a report. Now, how are you going to even know that? And again, this is such a new concept. Will people even know who to tell? Like, why would you even think that if a co-owner of an entity, a manager of an entity, and we're going to come to that, changes the home address, that you now have a filing due within 30 days? And there's pretty significant penalties for all this. What we may have to see, and this is where Alan's $150 for sure will go out the window, is we may start finding that for new entities, I could see, and I haven't really drafted language, I don't know if you've thought about it, Alan, yet, but we're going to start to see probably representations or acknowledgments in like an operating agreement for an LLC, a shareholders agreement for a corporation, that I agree as a shareholder that if I change my home address or any other fact that's reported under the Corporate Transparency Act, I will notify whether it's the government directly, the entity, if it has to do the filing, et cetera, within 20 days, because the filing has to be done within 10 days. We're going to start to see more of that. We may then want to see entity agreements amended for old entities to incorporate the language that we start to develop as lawyers to deal with all this, because you want everyone to be responsible. And not only responsible, the first step is they have to know about it in order to be responsible for it. Alan, comments, thoughts?
This 30-day thing, I'm expecting that the political winds will blow in Washington, D.C. If they don't push this whole law off a year or two, I think that this one will change.
30
It's
days is not reasonable.
It's completely unreasonable. It should just be that you would notify them the following year. They don't need to know that soon. That's crazy.
And that would make a lot more sense. And then when you do your annual tax return or annual report to the state for an entity, you pick it up then. That would make a lot of sense and be a lot easier. So ownership is very broad. Listen to how they define it on the bottom of 12. Any type of equity interest, profits interest, convertible instruments, warrants, options, puts, calls, or any other entity interest. And it can be controlled through joint ownership, through a trust agreement, indirect arrangements, etc. The bottom line is, it seems like virtually anything and everything is going to be captured within that. And that's important, Alan, because it sounds like to me that if you have some kind of like option on an interest in an entity, now you have to report. You're not the owner, you only have an option to get it. You're now pulled into this too.
Well, I mean, they have to do that so that people don't do silly things to avoid reporting.
Correct. But it's a broad net, and a lot of it's not intuitive. So I think one of the initial challenges of all this is because it's so different than things that we're used to doing, like a tax return, that people are going to have to get accustomed to it. Now it gets worse. I feel like late night TV, there's more. So if you're not an owner, but you exercise the authority, which this is the language right out of the law, the senior officer of the entity might hold, then you also may have to report. What does that mean? Could be a chief financial officer, general counsel. A trust protector may have to report. If a trust owns an entity and the trust protector has certain powers, or the investment trustee of a trust has certain powers over the entity, they may have to report. Again, keep in mind that the goal of the Corporate Transparency Act is to catch all of this stuff. The act generally applies beginning January 1, 2024, next year. So for new entities formed after January 1, 24, they want a filing done within 30 days of the creation of the entity. And I agree with Alan, 30 days is just too tight of a time period. We're going to all, in the legal and accounting and tax professions, going to have to become accustomed to anytime an entity is formed, a report's going to have to probably be generated as part of the package of creating the entity so that that 30-day deadline is not missed. And I agree with Alan. I don't know why they made such short deadlines that really don't give you much time. So let me give you my suggestions, and I'll see if Alan has any suggestions. I think the first challenge of the Corporate Transparency Act is just identifying all the entities. I've never kept records. Maybe Alan is smarter. I know he's better looking, but maybe he's smarter than me too. I've never really kept records of client entities in a fashion that will facilitate identifying who has to file and what they may have to file. It's just never been done that way. So we kind of have to create new records from scratch to identify these entities. Another thing, if I have a client that has co-counsel in Florida, maybe it's Alan, he may have set up an entity. I may not know about it. Alan may not know about all the entities I set up, even if it's a shared client. So you're going to have to start, and I think you should really start now, if you're a professional advisor, reaching out to clients. And that's why I wrote an article in our newsletter, so it went to everybody. But reaching out to clients saying, let's start getting lists together of every entity you have any interest in. Now, a starting point may be get the accountant for the client to list every entity they file a return for, see if any of the limited exceptions may apply for like an active business or regulated company like a bank. And then you have a list of many of the companies, but that's not enough because, as Alan and I discussed, a single member disregarded entity is not going to be on the radar of the accountant because they don't have a return to file necessarily. The lawyers that set up the entities have to get involved. So I think you need various advisors and the client themselves. If you're a client and not an advisor, I think you got to be responsible and get involved in this, because until we get a list together, we, meaning you, the client, the attorney, the accountant, until everyone collectively gets a list of every entity you have to file for, we don't know that we've got it covered. And the penalties are pretty severe. The next thing I think is to start to identify all the owners and then expand that list to all the people that may have control over the entity. And then you have to get the identifying information to make sure that you have what you need to file. So I think we all have to kind of start getting started now on this. And I'm not really hearing from anybody that they're really doing it yet. Alan?
Well, we have until January 1st, 2025 for entities that are now existing.
Right.
I think Congress is going to push this thing off, but I completely agree. As estate planners, though, Marty, shouldn't we have a chart or a knowledge on each client of every entity and how it's owned? I mean, that's part of putting together a good estate plan. That's part of putting together a
I,
good financial statement. I mean, this just helps us with that aspiration. It gives us a good reason to tell clients it's time to update their chart, time to make sure their planning's up to date so we
yeah,
can comply with law too.
listen, I don't feel that most clients come back nearly often enough. I recommend annual reviews. This is another reason you need it. I find that oftentimes the other advisors for a particular client, the various advisors, let me speak generically, don't really collaborate. If I set up something new for a client, I try to inform the accountant and the corporate counsel, and I'm not sure they do it back. And some clients don't want you informing or speaking to the other advisors. I'm just concerned that it's going to take a while for the first year's filings to identify all the entities. What about shelf entities? Do you have to file for a shelf entity? I think you do. Shelf entity, why don't you explain what that is real quick, and then we'll go on to our next topic.
Well, that's when I form 10 LLCs, and then as soon as a client needs one, I assign the LLC to them so they don't have to wait for me to form it. Of course, they're rare now, more rare now because the Secretaries of State allow electronic filing for most people. Marty, the other thing I'll mention is if you have a client that wants limited liability like an LLC, but doesn't want to have to do this filing, remember that the Uniform Trust Code basically says that when you have an irrevocable trust that's doing something, the trustee and the beneficiaries are not liable for negligence or inappropriate conduct unless they are negligent or engage in inappropriate conduct. So I do have clients where, for example, spouse one puts a rental house into a trust. Spouse two is the beneficiary. Is the trustee. The children are beneficiaries. Someone breaks their neck in the house. They can only go after people who were negligent or engaged in inappropriate conduct. The trust can be disregarded for income tax purposes and will not have to file under CTA.
Anyhow, this is a big sea change in what we do. In the end, it's not going to be a big deal, but the penalties are significant, and I encourage everyone to start giving thought to it. And I do think it's going to take some time to start getting this information together, and I encourage everyone to start sooner than later. Because don't forget one of the things that's going to happen. In 2024, in the beginning of the year, if this is not deferred, as Alan, I don't know if it was a prediction or just a wish and hope, if Congress doesn't defer these rules, you know, everybody in the legal and accounting profession and some of the other allied professions is going to be consumed with just grappling with dealing with this for new entities being formed. And then when that starts to calm down, because we get that under control, and no doubt there may be more guidance issued between now and then. And then we have to start getting information together for the filings for existing entities, which, as Alan said, is due January 1, 2025. So I just think it's a lot of advisors are going to be inundated with dealing with this, and some will frankly be overwhelmed. So I think the sooner you start pulling the information together, the better. And I do think that what's going to happen is you, the client, are going to have to coordinate with multiple advisors because not everyone's going to have all the information. I think I agree with Alan. Ideally, if I'm doing an estate plan, I should have the information on every entity that the client owns, but that's just not reality in a lot of cases.